Once more, welcome to our series. It's a continuation of the series on the admissibility of different types of evidence in South African courts. We have looked at the hearsay evidence, we have looked at opinion evidence in some of our videos, similar fact in previous consistent statements, admissions and confessions, and this one looks specifically at opinion evidence. Just sit back, relax, and then we'll hear from you. Comments, questions at the end of the video. Thank you very much. Yes, before we proceed, just a few preliminary questions. Have you subscribed to the channel? Have you hit that notification button? Are you sharing the videos with friends? I hope you are. Remember to support the channel so that it grows. As you like the videos and share with friends and join our chat groups and so on, you are helping the work to grow. Thank you very much. Just remember that, and as you share with your friends, remember to also build the network together with them so that we may proceed and grow the channel. Thank you very much. Yes, the following are some of our reading material. Your Hollington versus Houghton case that was decided in England in 1943. Look out for the full citation below. And then the R versus Vilbro, 1957. This is a South African case. And the S versus September 1996. These cases have actually applied some of the rules on on opinion evidence, and I hope as you read the cases you will get to understand how opinion evidence gets to be applied in courts. Remember that by the end of this video you should be able to define what we mean by opinion evidence, understand the scope of its application, as well as its inadmissibility in law, that is in South African courts. So just remember to keep yourself focused on those issues. Now take a look at this scenario. Two motor vehicles actually collide at an intersection. You find there was one driver maybe driving a big truck, and then there was another one, and they were driving at 90 degrees against each other. In other words, the intersection towards which they were driving, it gave them a 90-degree kind of relationship. That's the angle between the two roads. And then obviously after the collision, each driver has got a version of explaining what happened, what exactly transpired, why the accident occurred, and so on. And then there happens to be an onlooker, some passerby, who happened to be at that area at that time. And so now the matter is taken to court, and each one of the drivers is giving an explanation on what exactly transpired. And then because the onlooker also happens to have been there and is called as a witness in court, so there she is giving evidence. And one of the statements that she says is driver A, let's call it the truck driver, was actually wrong, is the one who caused the accident, because the traffic light was red. She claims that driver A, who is the truck driver, drove through a red traffic light, and so she concludes that driver A is actually to blame for the accident, while driver B was just an innocent victim. That's according to this witness of ours. Let's call her Z by name. Now, when you look at the statements that the witness Z makes, well, she tells us that driver A drove through a red traffic light. I think that's a fact. She's giving us her own observation, which could be a fact. But when she starts giving an opinion, expressing a view that because A drove through a red traffic light, therefore A is guilty, or A is the one who caused the offense, and therefore liability must lie with A. She is no longer stating facts as she saw them, but she is expressing a view based on an inference that she herself drew based on what she had seen. That's a typical example of what we call an opinion. Simply defined, an opinion is an inference or a fact or conclusion of fact drawn from other facts. In this particular case, our witness Z is drawing a conclusion from the fact that driver A drove through a red traffic light. So instead of her just simply telling us that the traffic light on A side was red and the traffic light on B side was green, she is now going a step further to draw some conclusions from whatever facts she observed. So we then come to say that she's expressing an opinion. So an opinion is an inference of fact or conclusion of fact. Remember, it's drawn from other facts. That's the defining element. And you notice that opinions may be given by laypersons or by experts. Let's imagine that in the same scenario, one of the passengers in the other vehicle died, lost their life, and then paramedics were rushed in. They drove to the place, and then they came in there, and they then took the people out, tried to put them in the ambulance, and then they concluded that one of them was dead. Now, the paramedic may have a specialized knowledge such that he or she may conclude that a person is dead based on whatever she has observed. But again, the questions would arise whether the paramedic is an expert enough to pronounce anyone dead, or is also expressing an opinion. But we will deal with those issues as we go further down. Now, as a general rule on the admissibility of opinion evidence, you find that opinion evidence of a witness is irrelevant because it is a function of the court to draw inferences and to form its own opinion from the facts. In other words, we need not be informed by the lay person. In fact, the lay person must not draw a conclusion which only the court should be competent to draw. The witness must just narrate the events as she saw them, and then leave the court to decide and determine whether as in the case of our motor vehicle accident there, it is the court that must decide based on the evidence provided whether A was guilty, he was responsible for the accident and is therefore guilty, or it was B's fault, and so on and so forth. Witnesses must confine themselves to giving testimony as to the facts, and then a court will form its own opinions. It is not the role of a witness to take over the function of the court and to opine and give opinions on logical inferences that can be drawn from the facts, but rather it's the prerogative of the court to draw such inferences from the facts. So the role of the witness is just to share the facts and then leave the court to express an opinion on them. And we are saying that opinion evidence is admissible in certain exceptional circumstances. We are going to look at the admission of expert evidence as well as admission of lay person's evidence. And we are saying in terms of some of these exceptions, opinions may be relevant in certain circumstances. For instance, the opinion of a medical doctor who examined a rape victim immediately after the ordeal, or a ballistic expert regarding the use of a firearm in the case of a murder or a robbery. We are going to look at the case of S versus September in 1996, which is quite informative in respect of this opinion evidence. So what are the circumstances in which opinion evidence is inadmissible? We find that a court may not rely on opinion evidence on matters which require ordinary knowledge and skill. There are certain matters where, there is no specialized skill that's required in order to reach a conclusion. So courts may not then rely on opinion evidence if they are competent on their own to find the truth and to express their own opinion. So we are saying, like, going back to our example there, where the witness Z is expressing an opinion that driver A was at fault. I think in that scenario, the court doesn't require any specialized knowledge from the witness in order to draw a conclusion on its own. And so we are saying courts may not rely on the opinion of that witness. If the court is in a position to consider the facts and reach its own conclusion, then the opinion of the witness is inadmissible. For example, a witness who states that the accused acted in a culpable manner and is therefore guilty, that kind of a witness is usurping the function of the court. And such a testimony is irrelevant and superfluous and uncalled for, if one could say. But when it comes to expert witnesses, the courts may be inclined to pay attention to what the witnesses have to say. And the question is, who is a witness? Sometimes it is the circumstances that define who a witness is. For instance, in Ara versus Vilbro in 1957 in South Africa, the opinion of a chief inspector of Indian and colored education was received to assist the court on a question of racial classification. Remember, those were the times when people were still being classified on the grounds of their race, and so children of a certain race would not attend a school which was reserved for a different race. So you find that there was this question about the racial classification of a particular learner, and then the chief inspector of this Indian and colored education was then called upon to help in the classification of that learner. And having expressed an opinion, the court admitted that opinion. And then the question is, did the inspector's experience qualify him as an expert witness? Was he being an expert witness? Would you say that when somebody has been working in a certain field of human involvement and enterprise for a long time, then they've become an expert in that field? That's quite a controversial proposition in itself. But it suffices to say, although not an expert strictest sense, so that is in the strictest sense, the chief inspector was in a better position than the court to draw the necessary inferences. As somebody who had been working in that area with children, the court accepted his testimony and his opinion on whether the child belonged to one race or there was or did not belong to that. And the issue is that when it comes to who an expert witness is, sometimes you find that it's not a very strict definition. There are no fixed classes of expert witnesses. Sometimes experience and exposure will suffice. But in other cases, a qualification, a formal qualification may be required. For instance, in the case of medical doctors and engineers, it may be required that the expert witness possess a certain qualification. You find that the Arra versus Vilpro case indicates that the reception of expert evidence could be ascribed to the principle that opinion is admissible when it can assist the court. So, as in that particular scenario, the court could not be in a position to reach a conclusion on its own. Hence, it accepted the opinion of that inspector as a witness, so that it could reach a verdict. And you find that the law usually strictly specifies the qualifications of experts whose opinions would be admissible in a given scenario. And we have a list there, well, not a complete list, an exhaustive list, but you find in areas such as ballistics, that's the use of firearms and so on, engineering and chemistry, medicine and medical science, accounting, psychiatry, the court would usually be inclined to accept the opinions of those. For instance, the court may not be schooled in knowledge of chemistry, so a chemist, somebody who has qualifications in that area, may then be competent to inform the court and express an opinion about whatever transpired and how the relevance of knowledge of chemistry actually helps there. Now there comes the issue on the evidence of a conviction in a criminal case. And in the case of Hollington versus Houghton, that was in 1943 in the United Kingdom, UK, you find that the court said that the evidence, rather the conviction of a particular person in a criminal court remains the opinion of that court. So when one tries to bring that evidence in the next case, it may actually be very problematic, because it's like bringing the opinion of one court into another court and expecting the second court to then deal with that particular either plaintiff or defendant, whoever it might be, on the basis of the opinion of another case or of another court. That may be very problematic. Now, this case was developed in terms of English law. It was actually decided in terms of English law in 1943. That was before South Africa became a fully fledged republic in 1961 on the 30th of May, capable of running its own legal system and not depending on English law. So you find that this case still applies in South Africa. Some jurists actually believe this is a very absurd rule, very strange and preposterous, if one would say. And well, it raised a lot of controversy in the United Kingdom itself in English law. So the Law Reform Commission of 1968 recommended that such a reasoning should be abolished completely and excluded from rules of English law of evidence. But because by 1968 South Africa was already a republic, and we know that in terms of the law of evidence, you find all rules of evidence that were applicable up to 30 May 1961 in terms of English law remain part and parcel of authentic South African law. So in terms of the Criminal Procedure Act 51 of 1977, as well as Section 42 of the Civil Proceedings Act 25 of 1965, you find that the law of evidence, including the law relating to competency, compellability, examination, and cross-examination of witnesses, which was in force in respect of civil proceedings on the 30th of May 1961, shall apply in any case provided for after this act or any other law. So you find that according to the Hollington versus Houston case, the conviction or the verdict of a criminal court remains the opinion of that court, and you find that the next court hearing, maybe matters on the same issues, is not obligated. So a civil court is then not obligated to admit the evidence being tendered in connection with the previous conviction. Well, we have said a lot about this rule, but simply stated, it's the rule. The rule in Hollington versus Houston is that the findings of a criminal court are mere opinion and are therefore not proof of the contested facts in the ensuing civil trial. And this English appeal court had to determine what it was faced with, whether a judgment of a criminal court could be used in subsequent criminal proceedings, or rather civil proceedings, to prove the liability of the litigants. And a judgment of a criminal court is an irrelevant and inadmissible opinion, so it's an opinion in later civil proceedings. The reason is that if a criminal conviction were admissible evidence, it would open the conviction up for the challenge by the defendant. So imagine then that maybe the plaintiff brings and accuses the evidence that the defendant has already been convicted in a criminal case on the same issues. Therefore, he must be found liable for whatever it might be the dispute, the issues that are being disputed. You find that then the defendant may want to reopen that trial and start questioning, raising questions about the conduct of the trial, whether it was properly conducted, and so on and so forth. What if it's still subject to appeal and all those other issues? So the reasoning is that let the civil court hear evidence on its own and then make its own decision. But so now the absurd scenario is one whereby, imagine that the plaintiff, or rather the defendant, is found guilty of an offense in terms of the criminal trial, and later on a preponderance of probabilities, that same defendant wins the suit in the civil case, so that the complainant in the criminal case ends up having to pay damages or whatever obligations to the defendant. It's really absurd, because then it gives us a very clumsy picture of the law. I think there is need to realign these issues. It's very critical that such is done. We find that Section 17 of the Civil Proceedings Act, Evidence Act, provides that a conviction or an acquittal can be proved by the production of a document duly certified by the relevant court that acquitted or convicted the person in question. It is, so in other words, the opinion of the court is admissible, but the court still has to evaluate it by itself. Another absurdity where the civil court now has to evaluate the credibility of another court. So it's a court sitting in judgment of another court. Very problematic conundrum there. So there are circumstances in which opinion evidence is admissible. For instance, the evidence of a lay person may be admitted in respect of scenarios where it is peculiarly within the competence of the witness to draw an inference from the facts. For instance, to estimate the age of the person. So if a person walked into a place and committed an offense, and then the court now maybe has two potential suspects before it, and it wants to establish who between the two of them. The witness may give an estimate of the age of the person who committed the offense. So to estimate the age of another person, or to estimate the state of drunkenness or sobriety of a person, or to summarize facts as perceived in respect where a person was angry or not angry. So the court may say, or one of the litigants may ask whether maybe the other person, the perpetrator, was angry or not angry. So opinion evidence of a lay person is accepted there, is admitted there. It may also be admitted to identify handwriting, like a teacher identifying the handwriting of a learner or a student. Does that turn the teacher into a handwriting expert? Certainly no. Sometimes opinion may suffice to estimate the speed of a vehicle. It may state the general state of a thing, e.g. whether it was new or old, whether it was hot or cold. So a witness must provide reasons for whatever opinion or inference he peddles. Then inability to provide reasons does not affect relevance of the evidence, but will affect the weight. So if a witness's opinion is not challenged, the court must exercise discretion whether to admit it or to reject it. That's very, very important to consider. So talking about expert evidence, we are saying that it is led in respect of whatever issues might be there, and then it must be evaluated by the court. Experts are usually called to evaluate circumstantial evidence, and then the expert evidence must assist the court. We've spoken about the expert in the case of S versus Vilbro, the R versus Vilbro, when we spoke about the education inspector. And we are saying there are three requirements that must be satisfied prior to the admission of this expert evidence. The court must be satisfied of the witness's competence to furnish expert evidence. And so it must verify the expert's qualifications, experience in the field, track record regarding giving of such evidence. And the court must also generally be informed of the grounds and the reason upon which the expert opinion is based. So the expert who is giving opinion must lay a groundwork for the opinion. Why does she hold the opinion that she does? What reasons justify that kind of an inference or conclusion or opinion? And the court must compare the expert's opinion with the facts provided by other witnesses and the evidence, as was the case in S versus September 1996, which was dealing with medical doctors' opinions in criminal capacity of an accused. And then the court need not rely on expert evidence and may dispense with such evidence after evaluating it and maybe establishing that it is not credible enough. And we are saying that in matters of highly technical competence, the court may have to fully accept the evidence of the expert, that kind of thing. So that's as far as expert evidence is concerned. Yes, we have come to the end of our lecture. Let's just look at the summary of the issues that were discussed. We said that an opinion is a factual inference drawn from the analysis of other facts, and it is given either by laypersons or by experts, and its admissibility is based on the principle of relevance. So it goes without saying that if it's not relevant, it will not be accepted. Just like in respect of all other forms of evidence, relevance is the criteria that goes before everything else. And the opinion of an expert or even a knowledgeable person will be relevant and therefore admissible if it can assist the court in its fact-finding mission. And there is this strange rule in Hollington versus Houston, decided in 1943. And we spoke extensively about it, whereby we said that it was decided in 1943 and it's still applicable in South African law even now. Not how this rule relates to Section 17 of the Civil Proceedings Act of South Africa, that is of 1965. We've come to the end, and remember, this video looked at opinion evidence, and there are other videos that are dealing with character evidence, similar fact evidence, previous consistent statements, admissions, and confessions. And there are others also on matters such as privilege and matters such as the evaluation of evidence, how to reach a verdict and so on, how courts reach a verdict based on the evidence that is before them. No, so we have all these other videos on privilege, treatment of evidence, evidence obtained in violation of the Constitution and so on. You must familiarize yourself. In fact, look out for those videos and get a full view, a full panoramic view, a full spectrum of the law of evidence as we have it. Once more, thank you very much. Remember, if you have not already subscribed to the channel, do so now. Click that notification button so that when we share videos in future, you may also be a partaker of them. Thank you very much. Enjoy the rest of your day.